afternoon. I'm Stephen Lewis, and today I'm going to be talking about the Civil Rights Act of 1866, its impact, legacy, and contested boundaries of citizenship. This is a design master's level course. Today we're going to use the Civil Rights Act of 1866 to think about a core question in U.S. history. Who gets to count as a rights-bearing person? This act is often summarized with a few familiar slogans. The first federal civil rights, the first civil rights statute, the law that overturns Dred Scott, or the precursor to the 14th Amendment. All of that is true, but it can flatten out what's really at stake. I want us to treat the act as doing three things at once. It reconstructs citizenship in the wake of slavery. The federal government, not the states, is going to define who is a citizen and what basic civil rights they have. It creates a bridge from wartime emancipation to the later constitutional settlement in the 14th Amendment and to modern civil rights law in the 20th century. It's also a contested site while it expands rights for formerly enslaved people and many others. It simultaneously draws and policies polices boundaries, most obviously with its explicit exclusions of Indians not taxed. As we go, I want you to keep in mind not just what the act does legally, but what it tells us about the kind of political community the United States is trying to build at this moment. Let's situate the act in its immediate context. By early 1866, slavery as a legal institution is gone. The 13th Amendment has been ratified, but freedom without clearly defined legal status is incredibly precarious. In the ex-Confederate states, white elites try to reassert control through the black codes, laws that restrict black mobility, limit which trades free people can pursue, and use vagrancy and contract rules to push them into quasi-coercive labor arrangements. Overlay that with the legacy of Dred Scott v. Sanford in 1857, the Supreme Court declared that people of African descent could not be citizens of the United States. That decision isn't just about slavery, it's about who belongs in the American polity at all. Even with emancipation, Dred Scott is still sitting there formally undecided, poisoning the legal landscape. So, Republican lawmakers in the 39th Congress are facing a dual problem. First, how to block the black codes and protect free people from being pushed back towards slavery in all but name. Second, how to define citizenship and civil rights nationally. Instead of leaving it to the states that are openly hostile to black freedom, Civil Rights Act of 1866 is their first major experiment in solving those problems through federal statute. Section 1 of the act opens with a bold move. It declares that everyone born in the United States, subject to certain qualifications that we'll unpack later, is a citizen of the United States. Think about how radical that is in 1866. Less than a decade earlier, Dred Scott said that black people had no rights, which the white man was bound to respect, and could not be federal citizens. Congress is now saying, no, we are going to repudiate that by statute. We're going to assert that birth on U.S. soil makes you a citizen. There are two key points to emphasize for your historical lens. First, this is birthright citizenship before the 14th Amendment. The amendment will later enshrine this principle in constitutional text, but the statute hits the ground first. Second, this is a federal definition of citizenship. The message is states do not get to decide on their own who counts as a citizen. That's a national question, and Congress is claiming authority over it. So from the very first sentence, the act is trying to rebuild the political community after slavery by saying that here is who belongs and here is who has a right to basic civil standing. After defining citizenship, Section 1 moves into a list of specific civil rights that all citizens must enjoy equally. The structure is explicitly comparative. Non-white citizens are guaranteed the same rights as is enjoyed by white citizens. White status is the benchmark for equality. That framing tells us this is not just about formal abstraction. This is about aligning the legal status of newly recognized citizens with the already privileged status of whites. The listed rights fall into three main clusters: contract rights, the right to make and enforce contracts, the backbone of participation in a capitalist labor and credit market. Legal process rights, the right to sue, to be parties, to give evidence in court. This directly strikes at black codes that barred black testimony against whites. Property rights, the right to inherit, purchase, lease, sell, hold, and convey real and personal property. Here, the act is targeting rules that tried to keep land and wealth out of black hands. Finally, there's a catch-all promise of the full and equal benefit of all laws for the security of persons and property. That moves beyond individual transactions and gestures toward a more general equal protection principle later echoed in the 14th Amendment. Notice what this list doesn't include: voting, office holding, jury service, and school integration. The act is overwhelmingly focused on what we might call civil and economic rights. Political rights will be addressed more directly in later measures, especially the 15th Amendment. So we see a particular theory of what's most urgent: access to markets and courts as a starting point for free citizenship. The act does not simply announce rights and hope for the best. It builds an enforcement apparatus that is just as important as the rights language. It makes it a federal crime for any person acting under cover of any law to deprive someone of these rights. That phrase, under cover of law, is the ancestor of modern civil rights doctrine that goes after state actors who abuse their authority. It also gives federal courts jurisdiction to hear cases involving gives federal courts jurisdiction to hear cases involving violations of these rights. That's a big deal. Traditionally, civil disputes and local criminal enforcement had been left largely to state and local courts. Here, Congress is inviting people to bypass state systems that may be unwilling to protect black rights and go straight into a federal forum. All that raises immediate constitutional questions: on what basis can Congress legislate so deeply in what had been state domains? Many Republicans argue that Section 2 of the 13th Amendment, the Enforcement Clause, authorizes Congress to abolish the badges and incidences of slavery. They interpret contract property and illegal disabilities imposed on black people as just that, lingering incidents of slavery that the federal government must remove. So the act is not only about race and rights, it is also a major experiment in federal power over states in the name of civil rights. Now I want to pause the celebratory narrative and zoom in on a phrase that often gets glossed over in textbooks. The very first sentence of the act declares that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are citizens of the United States. That exclusion is doing real work. The phrase Indians not taxed comes from earlier constitutional language, especially in apportionment provisions. It was a way of categorizing most Native people as outside normal state tax and jurisdiction systems, as members of separate political communities in a kind of quasi-foreign status. What this means in practice is that the 1866 Act's new birthright citizenship regime does not automatically embrace most Native people at precisely the moment Congress proclaims that birth on U.S. soil establishes national citizenship regardless of race or color. It is explicitly carving out tribal Indians as an exception. So the act is doing something paradoxical. It is dismantling a racial caste system rooted in chattel slavery by affirmatively incorporating formerly enslaved people and other non-white residents into citizenship, but it is reaffirming a different kind of racialized and colonial boundary by leaving Native people in a limited subordinate status. We might call this selective universalism. The law universalizes civil status in one direction while hardening colonial lines in another. This will have a long afterlife of cases like Elk v. Wilkins and much later in the Indian Citizenship Act of 1924. Before we move back to black codes and enforcement, I want you to sit with this tension for a moment. One way to frame this slide is a challenge to the linear story of progress. If we narrate the Civil Rights Act of 1866 only as a heroic breakthrough for racial equality, we risk ignoring the groups that it continues to marginalize or exclude. So I'd like you to think about these questions. If we take the exclusion of Indians not taxed seriously, is this primarily a racial justice measure, a nation building measure, a settler colonial measure, or some uneasy combination? How does the story of Reconstruction change if Native peoples are not simply a footnote, but are centered in our analysis of citizenship and rights? Turning back to African American freedom struggles, the most immediate practical target of the act is the black codes. In state after state, these codes require black laborers to sign annual contracts under highly unequal conditions, restricted what kinds of property they could own, especially land, barred them from testifying against white people in court, making it almost impossible to seek legal protection from violence or economic exploitation. Civil Rights Act goes straight at these features by guaranteeing equal contract and property rights and by opening the courts to black litigants and witnesses. Republicans defend the act as an implementation of the 13th Amendment. They argue that even if slavery is a legal status is gone, the badges and incidents of slavery, the social and legal structures that mark black people as inferiors remain. The federal government, they insist, has not only permission but an obligation to remove these. That framing badges and incidents of slavery will become critically important a century later when the Supreme Court revisits the 1866 Act and reconstructs it as a basis for tackling private discrimination in housing and employment. President Andrew Johnson responds with a lengthy veto message that crystallizes the opposition. He makes two kinds of arguments. Constitutional argument, Johnson claims that civil rights, especially those related to contracts, property, and local legal processes, are matters reserved to the states. From his perspective, a national law that standardizes civil rights effectively destroys state autonomy and imposes a centralized regime that the Constitution does not authorize. Racialized fairness argument, Johnson also suggests that the bill would unfairly privilege Black Americans. He contrasts freed people whom he portrays as newly elevated with white immigrants who have intelligence and patriotism, but must wait years to naturalize. This is an early example of something that will become very familiar later, using a rhetoric of reverse discrimination or special treatment to oppose race-conscious protections. Congress, of course, overrides the veto. That override is more than a procedural footnote. It marks a turning point where the legislative branch asserts a robust Reconstruction agenda over Congress rather than the executive drives civil rights policy. If we stop the story with the statute and the veto override, we might think problem solved. But as historians, we know we have to distinguish between law on the books and law in action. Enforcement of the act is highly uneven. Many federal officials and judges are indifferent or hostile to Black claims. Jurors and local power brokers may simply ignore what the statute says. At the same time, white Southerners are organizing violent resistance through paramilitary groups, Klan violence, and everyday terror to intimidate black people who try to exercise these new rights. So even if the law says you can contract freely and go to court, you may risk your life if you actually try to do so. Economically, systems like sharecropping and debt peonage emerged, trapping many black families in dependent, exploitative relationships that keep them from accumulating property or leaving the abusive arrangements. All this means that the formal equality promised by the Act does not translate neatly into substantive equality on the ground. This gap between what statutes declare and what social structures permit should shape how we assess the impact of the Civil Rights Act of 1866. It's powerful, but also deeply constrained by the political and economic realities of Reconstruction. The 1866 Act doesn't vanish after Reconstruction, it evolves. Congress reenacts the core provisions after the ratification of the 14th Amendment, partly to quiet doubts about its constitutionality and partly to anchor it in the new constitutional order. Over time, the language we've been discussing ends up codified in the U.S. Code as Section 1981, focused on the right to make and enforce contracts and to enjoy equal benefits of laws and proceedings. Section 182, focused on equal rights in property transactions, especially real estate. For a long stretch from the late 19th century through much of the early 20th century, these provisions are underused or read narrowly by the courts. But in the Civil Rights era, litigators and sympathetic justices rediscover them as tools for going after racial discrimination, especially in housing and employment, including private discrimination. So you can think of the 1866 Act as having a kind of dual life or Reconstruction function that aimed at black codes, and then a later life as a key component of modern civil rights enforcement. Two landmark Supreme Court cases show how the 1866 Act gets reimagined in the 20th century. First, Jones v. Alfred H. Mayer Company. In 1968, in Jones, a black man is refused the chance to buy a home in a private subdivision solely because of his race. He sues under Section 1982. The court holds that Section 1982 prohibits private as well as public racial discrimination in property transactions, and that Congress had power under the 13th Amendment to enact such a law. The key move is to treat private housing discrimination as a modern badge or incident of slavery. Second, Runyon v. McCrary. Here, white-run private schools refused admission to black children. The court holds that Section 1981 reaches private contractual discrimination in the context as well. Taken together, Jones and Runyon say that these Reconstruction era statutes can be used to regulate private actors, not just state officials, when Congress is acting under the 13th Amendment's enforcement power. Later cases will refine the details, requiring proof of discriminatory intent in some context, debating how strong the causal connection must be between race and outcome. But the core principle remains the Civil Rights Act of 1866 provides the legal foundations for a robust attack on modern forms of racial subordination in markets.